Can an officer order you out of the vehicle during a routine traffic stop, or is that a violation of your rights? That's what we're going to be addressing in this video. And before you get the answer, let me know, what are your thoughts? Can they do it? Or is it a violation of your rights? You're going to get the answer in this video. I want to welcome you back if you've watched some of my videos before. If not, my name is Jamal Kersey. I'm a criminal defense attorney. I've been practicing law for over 15 years. And on this channel, we're breaking down legal concepts so you're in the know. So again, the question that we're answering in this video is, can the police order you out of the vehicle after a routine traffic stop? And this can be an annoying situation. I've had it happen to me. I remember me and one of my best friends, Tyree, we were driving around, and Tyree and I were only a few months apart, both African-American. We were teaching music together at the time, both went on to be an attorney. And so we have a lot of parallels in our lives. But at this time, we were probably around, 18 or 19 years old. Tyree had a pretty new car at the time. And I believe that the only reason we got pulled over is because we were two young black teenagers in a newer car, right? So we get pulled over. Officer naturally asks, why I pulled you over? I don't remember what the response that Tyree gave, but they asked for the license, registration, insurance, and Tyree produces it. They go back to do their check to see, if the vehicle's stolen or whatever, or see if we're on probation or anything like that. They order us out of the vehicle. And both of us, we were annoyed by it, right? We knew we weren't doing anything wrong. I don't know where we were going, but it didn't matter. They were interrupting our evening by pulling us over. But, one thing about me, I know that people have different philosophies in their dealings with police, but I treat police respectfully. I'm not a bootlicker. I'm not, kissing butt, but, I don't have any reason to treat officers with disrespect. I think that you should, just as a general principle in dealing with people, you got to give respect to get it. But that's just how I operate. I treat officers with respect, and neither one of us were disrespectful, but we were annoyed that we were being ordered out of the vehicle. And so, they run their checks, everything's good. The car's not stolen. They ended up sending us on our way, and we were like, man, this is some BS, whatever. And we never actually talked about it again. But the question would be, were they justified in ordering us out of the vehicle in that situation? And so there is a Supreme Court case that directly addresses this issue. And this is one of the things that comes up in criminal procedure in law school, right? In law school, there's this class where they go through all these cases that interpret the Fourth Amendment, right? The Fourth Amendment of the Constitution is what protects us as citizens from unreasonable searches and seizures, and we go through the warrant requirement. But you learn that there are a bunch of exceptions to the warrant requirement, right? And so you have all these Supreme Court cases interpreting the Fourth Amendment and determining what is reasonable and what is unreasonable when it comes to police activity. So let's dive into Pennsylvania versus Mims, because that's where we're going to find our answer to whether the officers can do this. So this was a 1977 case, so it's pretty old, but what ended up happening was Mr. Mims, Harry Mims, was driving around and he had expired tags, right? So two Philly cops saw this vehicle driving around, saw the expired tags, and they decided to pull him over in order to issue him a ticket for the expired tags. So they asked for license, they asked for proof of ownership of the vehicle. They also asked Harry and his passenger to get out of the car. So when Harry gets out of the ar, the officer sees, he had kind of a sport coat on or a sports jacket, and the officer saw a bulge. So the officer decided to pat him down, and he found a firearm hidden in Mr. Mims' waistband. And it turned out that his passenger also had a gun on him, right? So Mims ends up getting arrested. He was indicted, which means that, there was a probable cause finding that he was carrying a concealed weapon unlawfully, and he was carrying a firearm without a license, right? So his lawyer, I'd imagine he had a conversation with his lawyer saying, hey, man, yeah, I got pulled over. I had expired tags, but they ordered me out of the vehicle. Not only that, but then they patted me down, and that's when they found the gun. So the lawyer's like, bet, all right, Well, I think we can challenge this, right? I think they violated your constitutional rights because what right did they have to order you out of the vehicle, right? You figure he was just pulled over for an administrative violation, right? It should have just been, all right, you have expired tags, figuring out what the situation is, issue him a ticket and let him be on his way or whatever you were going to do, but you didn't need to order him out of the vehicle, right? So they filed a motion to suppress. That motion to suppress, challenging the officer's actions, ended up getting denied. So he ended up going to trial, and this had to be the shortest, simplest trial ever, right? Because the officer was just going to testify, hey, I saw this vehicle driving around, it had expired tags, I pulled him over, I asked him to get out of the car, I saw that he had a bulge, I patted him down, he had a gun. That's what it was, right? So the jury didn't have a lot to have to work with. So the jury ends up convicting him. He appeals. So the case goes to the Pennsylvania Supreme Court, and they actually reversed the conviction. Why? Well, they said that the gun should have been suppressed. It should have been thrown out when the lawyer filed the motion to suppress. And so basically what they found was that the officer had no objectively observable facts to support a suspicion that there was criminal activity afoot, which basically means, there was nothing to suggest that they were about to commit a crime, or that the occupants of the vehicle posed a threat to police safety. So they were analyzing whether the officers ordering them out of the vehicle was okay. And they said no, because you can't point to anything to show that they were about to commit a crime or that they were otherwise dangerous, right? And so, in thinking of what would indicate that maybe there was criminal activity afoot, let's say when they pulled the vehicle over, that they looked in the window and saw on the floorboard, they saw, some gloves, a poo shiesty mask, a gun, and a crowbar, right? So that might suggest that they're about to commit some burglaries, right? You throw some Nike, some black Air Force Ones, right? And it gets even worse, right? So that might suggest that someone's about to commit a crime, right? But with these two guys, there was nothing there, right? So, they got pulled over for the expired tags, but when the officers had the interaction, admittedly, there was nothing to show that they were up to no good, and there was nothing to show that, they necessarily posed some sort of threat to safety. So the Pennsylvania Supreme Court found that based on this, the officer ordering them out of the vehicle was unreasonable, and so therefore the pat down and the search and the finding of the gun, was unreasonable. This was basically the fruit of an unconstitutional search, and so therefore the gun should have been thrown out. So obviously the prosecutor didn't agree with the Pennsylvania Supreme Court's decision, so they appealed, and it ended up going to the United States Supreme Court, right? And so they had to analyze whether there was a violation of the Fourth Amendment. And so they opened by basically saying that the touchstone of the analysis under the Fourth Amendment is always the reasonableness in all the circumstances of the particular governmental invasion of a citizen's personal security, right? So then they go on to say what reasonableness is, right? And so they say reasonableness depends on a balance between the public interest and the individual's right to personal security, free from arbitrary interference by law enforcement officers, right? So we have to balance public interest versus a person's individual personal security. And so they had to start with the traffic stop itself, because if there was a problem with the traffic stop, then everything gets thrown out, right? So for example, in DUI cases, if you're driving under the influence of alcohol, and you shouldn't do that, don't drive under the influence, but if you're driving under the influence of alcohol and you end up getting pulled over, that officer has to have probable cause for the initial stop. It's not just enough to say, oh, well, he was in the bar parking lot at 2 a.m. and we saw him come out of the parking lot, and so we decided to pull him over. No, that's not enough. They have to have some sort of other violation of the vehicle code or some sort of indication that you might be driving under the influence of alcohol to pull you over. So if you're in a situation where you end up getting pulled over and it does turn out that you were driving under the influence of alcohol, but they did not have probable cause for the stop, then the BAC results, whether that's breath or blood, that all could be thrown out because of the violation of the Fourth Amendment rights. Man, I lost a light, but we're going to keep it rolling. So the stop was good, right? There was no issue with the stop, and they set aside the issue of the pat down, right? So they wanted to focus their attention on whether the officer was justified in ordering the guys out of the vehicle. And so then they say, all right, what was the reason? What was the stated reason why the officers ordered them out of the vehicle? And so the prosecution basically said, hey, we concede, we admit the officer had no reason to think that there was any sort of foul play going on. There was nothing unusual. There was nothing suspicious about the driver or his passenger's behavior. But the reason that the officer gave is he said, listen, I order everybody out of the vehicle, right? If I pull somebody over, it doesn't matter if they're black, it doesn't matter if they're white, it doesn't matter if they're male, female, young, old, everybody gets ordered out of the vehicle for my safety. So then the Supreme Court starts analyzing whether it's reasonable for an officer to be concerned about their safety during a traffic stop. And, traffic stops are extremely dangerous for law enforcement officers. And they went on to say that 30% of police officer shootings happen during a traffic stop. And they say a significant percentage of murders of police officers happen during traffic stops. And, there's all kinds of ways that people end up attacking officers during a traffic stop. They can use their vehicle as a weapon itself. Sometimes they might be armed with a gun. Sometimes they might be armed with a knife. They could be armed with anything, but it's dangerous, and there's no way to really know who's going to be that person who is going to attack the officer. So the Supreme Court basically accepted that an officer's reasoning that their safety might be compromised during a traffic stop. They're like, hey, okay, we're going to accept that. So with the Supreme Court finding that traffic stops are dangerous, that's not where the inquiry stops, because they have to balance the officer's interest in their safety along with the citizens' interest in being free from unreasonable intrusion. But what the Supreme Court found was that this intrusion is minimal. It's de minimis, right? And so when they balance the concerns for officer safety with a driver's inconvenience, basically the officer's concern for safety prevails. And so therefore they found that there's not anything wrong with an officer ordering somebody out of the vehicle in the interest of their safety. So since it was found to be lawful for the officer to order Mims out of the vehicle, the Supreme Court then analyzed the search. They said, hey, if he observed a bulge, then the officer was well within his right to pat the guy down in order to ascertain whether this was some sort of weapon or something that could compromise the officer's safety. And so therefore, then finding a gun in the waistband, he was justified in doing the search and seizing the gun. So the United States Supreme Court ultimately reversed the Pennsylvania Supreme Court's reversal, and they sent it back down for remand. So he basically would have been sentenced at that point. But the major takeaway from this case is that an officer, if they pull you over and the stop is legitimate, then they can order you out of the vehicle in the interest of officer safety. And that's regardless of whether you're up to no good. That's regardless of whether, anything that they see would indicate that you pose a risk of safety. They don't have to actually make those findings, because that was clear from this case. There was nothing to suggest that these guys were, about to commit a crime, had already committed a crime, or were in the process of committing a crime, right? There was nothing to suggest that, and there was nothing to suggest that they were dangerous. But nonetheless, officers were permitted in that case, and they are permitted now, to order you out of the vehicle. So knowing that it's not a violation of your constitutional rights for officers to order you out of the vehicle during a traffic stop, if you get ordered out of the vehicle, it's best to just get out, right? You shouldn't argue with them. You shouldn't question why. Just get out of the vehicle. You don't want to escalate the situation to a place where it doesn't need to go. If they ask you if they can search the vehicle, it's very important to say, I do not consent to any searches of my vehicle, of my person, because if you give them consent, that they can search your vehicle. If they decide to search your vehicle anyway, don't physically obstruct them or block them in any way. What you want to do is, remain calm, remain professional, and allow your lawyer to fight the situation in court. You win these battles in the courtroom, not on the street. The other thing is, when you are ultimately challenging officers' conduct or misconduct, right? It always looks a lot better if you are the person who kept your cool, you were nice about the situation, you were professional, versus even if the cop is in the wrong, if you're yelling, if you're being belligerent, if you're being disrespectful, if you're being rude and all of that, then it makes it harder, right? Just from a subconscious, from a psychological standpoint, it makes it harder for a prosecutor or a judge to be aligned with you, because there's going to be a natural resistance based on your conduct. I'm not saying that, you being disrespectful then justifies police misconduct, but in trying to, have your lawyer fight the situation, if you're being the reasonable one and you're being calm and professional, it just makes the road easier for the challenge in court. So that's the answer. Let me know if you have any questions on this or any other questions. I try and get to them as soon as I can. And how did you turn out? Did you guess right or were you wrong? Did you learn something? If you did, let me know. And if you got something out of this video, please show me some love and hit the like button. Make sure you're subscribed to the channel and turn on those notifications so you never miss a new video when it drops. And if you happen to be facing criminal charges and you're in Southern California, then we can help. You can reach out to us at 619-399-3366, and we'd be happy to offer you a free initial strategy session and see how we can help. Well, as always, I want to thank you so much for watching, and until next time, peace.